What do you want us to open, Doctor?
1180 matlab PDF, that compilation of last evening.
Para 143 that we were.
I'm grateful. 142 is over, 143 and 144 gets
Volume.
Baroness Hale over.
Volume 2.
Not precedent. Volume 4 foreign. मेरा तो volume 4 है. Foreign.
Yesterday evening, Baroness Hale, PDF 1180, para 143.
Volume 1.
Volume compilation 4.
Volume 4 foreign judgments.
Yes, it's actually open.
It follows.
Just a moment, please.
143 you were reading.
got it.
Correct, correct,
That's where we stopped yesterday.
correct, please. May I read?
Yes, please.
Yes.
It follows that a homosexual couple whose relationship is marriage-like in the same way that an unmarried heterosexual couple is marriage-like are indeed an analogous situation. Any difference in treatment is based upon their sexual orientation. It requires an objective justification if it is to comply with Article 14. Whatever the scope for a discretionary area of judgment in these cases may be. This is very beautiful, but it can be transplanted subject to my Lord discretion to the Indian Supreme Court, to our Article 14. Whatever the scope for a discretionary area of judgment in these cases may be, there has to be a legitimate aim before a difference in treatment can be justified. But what could be the legitimate aim of singling out heterosexual couples for more favorable treatment than homosexual couples? It cannot be the protection of the traditional family. The traditional family is not protected by granting people
43.
which is denied to people who cannot or will not become a traditional family. What is really meant by the protection of the traditional family is the encouragement of people to form traditional families and the discouragement of people from forming others. There are many reasons why it might be legitimate to encourage people to marry and to discourage them from living together without marrying. These reasons might have justified the act in stopping short at marriage. Once it went beyond marriage to unmarried relationships, the aim would have been to encouraging one sort of unmarried relationship and discouraging another. The Act does distinguish between unmarried but marriage-like relationships and more transient liaisons. It is easy to see how that might pursue a legitimate aim, and easier still to see how it might justify singling out the survivor for preferential succession rights. But as Lord Justice Buxton said, it is difficult to see how heterosexuals will be encouraged to form and maintain such marriage-like relationships by the knowledge that the equivalent benefit is being denied to homosexuals. The distinction between heterosexual and homosexual couples might be aimed at discouraging homosexual relationships generally, but that cannot now be regarded as a legitimate aim. It is inconsistent with the right to respect for private life according to everyone, including homosexuals, by Article 8 since Dudgeon's case in 1981. If it is not legitimate to discourage homosexual relationships, it cannot be legitimate to discourage stable, committed, marriage-like homosexual relationships of the sort which qualify the survivor to succeed to the home. Society wants its intimate relationships, particularly but not only if there are children involved, to be stable, responsible, and secure. It is the transient, irresponsible, and insecure relationships which cause us so much concern. Last para to be read. I have used the term marriage-like to describe the sort of relationship which meets the statutory test of living together as husband and wife. As husband and wife. Once upon a time, it might have been difficult to apply those words to a same-sex relationship because both in law and in reality, the roles of the husband and wife were so different and those differences were defined by their genders. That is no longer the case. The law now differentiates between husband and wife in only a very few and unimportant respects. Husband and wives decide for themselves who will go out to work and who will do the homework and childcare. Mostly each does some of each. The roles are interchangeable. There is thus no difficulty in applying the term marriage-like to same-sex relationships. With the greatest respect,
Dr. Singhvi, this was a case where
Yes.
the Act squarely applied to unmarried relationships.
Yes.
And the principle was that if you're unmarried, if the Act applies to unmarried relationships between heterosexuals,
Yes.
there is no basis to exclude unmarried relationships among homosexuals.
It is the second last
Right.
formulation of
That's
the
what it
sentence
said.
which I am concerned about, that when you have a particular paradigm applying to a heterosexual group, your lordship, Malas, absent something very special, will find it discriminatory not
That's
to apply
what
it
the
to
judge
others.
uses, Baroness Hale uses the expression marriage-like relationships.
Yes.
So these are not marital relationships, marriage-like relationships of heterosexual couples who are in a stable relationship but who are not married. They said that therefore, if you are extending protection to heterosexual couples who are in a marriage-like relationship and therefore not married, there's no basis to deny it to homosexual couples who have a marriage-like relationship but who are not married.
I'm
That's the
grateful, Mulus. That's one. But Mulus, the language of the paras I've read yesterday and today
may be
are
also
very, very
capable of
Mulus,
extension. You're right.
appropriate. And your lordship is not bound by these judgments. Your lordship will find persuasive value to the extent your lordship finds. Now I turn to that article, Mulus, which according to me is one of the most well-written articles on interpretation. On reading down, reading up, what your lordship
Well, which is that article now?
treaty compliant, or in our case, constitution compliant reading. Constitution compliant reading. Kindly hand over. Mulus. It's better to use the hard copy. I'll read only 3 sections, a few pages of it. Kindly hand over.
Oh, okay. Sorry, I was just. Thanks.
We also emailed you, but this is better and quicker. Mulus. The lordship may mark this.
The judgment is done.
That is done. That is over, Mulus. Now, kindly come to the first page. What is the year of this? What is the year of this publication? Don't do multiple things. Focus. Year. Just come to Mulus, the first para. Your lordship will ignore. I mean, it's about UK and New Zealand. Second para on the first page. On the first, I'll be Mulus, making your lordship mark only some portions. It's rather well put, Mulus, and it is triggered by. That's the reason I'm citing it. The key question for the courts in applying such directions is how to determine when it is or it is not possible to ascribe a rights consistent meaning to the legislation. Although a definitive answer to that question has proved unsurprisingly elusive, a shared assumption to date has been that the line that is being drawn, this is the point for this, line that is being drawn between interpretation on the one hand and legislation on the other. The task assumed by the courts is to search for an interpretation of the relevant statutory provision that would bring it into conformity with human rights standards. Now come to page 2, Mulus. Beyond the margins of interpretation, however, lies the constitutionally impermissible territory of judicial legislation. And that's your lordship's Mulus, equation. The next para, Mulus, given this characterization as essentially interpretive, it is perhaps unsurprising that well, I'll skip the New Zealand specific para, come to the third para. In the United Kingdom, however, and this is important, Mulus, a new model now seems to be emerging. In a series of cases, culminating in the decision of the House of Lords in Ghedan, I just read it, the United Kingdom courts have cast doubt over the centrality of statutory language to the determination of whether a rights compatible reading of legislation is possible in the right of the Human Rights Treaty. The text is not, the law lords have said, determinative. The text is not determinative. Rather, the courts will be constrained only, mark the word only by the underlying thrust of the legislation A and the limits of their institutional capacity. Now, Mulus, the counter question, the devil's question, is posed in the next paragraph. This paper discusses Ghedan and its implication. It suggests that the remarkable aspect of Ghedan is that it simultaneously divorces the process of statutory interpretation under HRA from the twin anchors of parliamentary intention and statutory text. This I'm relying upon heavily, Mulus, this first sentence. The second part, in that light, it is suggested that the dichotomy between interpretation and judicial legislation is at the very least under pressure, and the courts are in fact appropriating to themselves a significant, if nevertheless a subsidiary slice of legislative power. Now come to Mulus, page 8. Is it page 8? No? Where did you write it down? Page 8. Of the 4 law lords in the majority,
Yes.
of the 4, page 8, Mulus, 8. Roman, big Roman 2. Of the 4 law lords in the majority, the names are given. All but the last delivered a separate opinion on the correct methodology under 3.1. There was, however, substantial agreement on these essential principles. Then the key issue, separating the sheep from the goats. Their lordships identified the key issue under 3.1 as being how to determine the limits of what is possible. The scheme of 3 and 4 of the treaty envisages that there is a Rubicon which the courts may not cross. What is not, however, spelled out is the test to be applied in separating the sheep from the goats. Parliamentary intention is not the touchstone. This is another red herring which your lordship may have to deal with in the present case. In investigating the line between the possible and the impossible, Lord Nicholas and Lord Stein held that the courts were not constrained by the intention of the Parliament that enacted the legislation. Very, very important. Lord Nichols distinguished the required approach in this respect with the orthodox approach to standard statutory interpretation, which involves seeking the intention reasonably to be attributed to Parliament in using the language in question. In contrast, Section 3 may require a departure from that parliamentary intention. Departure from that parliamentary intention. The key question being how far and in what circumstances. This is because there is another and countervailing parliamentary intention which needs to be given full weight. Namely, the intention reasonably to be attributed to Parliament in enacting 3. So it's an objective test being brought in. Objective. Now, nor is the statute. The second thing which is not determinative is statutory text. And it is quite interesting and astonishing, though now in a constitutional context, American English courts are saying this. When we were brought up, it would be sacrilege to suggest this to an English court. Remarkably, their lordships held that the language of the statutory provision at issue is not the touchstone in deciding which it is not possible under 3.1. This holding had a number of dimensions. Further, their lordships expressed concern about excessive concentration in a literal or technical way on the linguistic features of the statute. Rather, Section 3 requires a broad approach, concentrating amongst other things in a purposive way on the importance of the fundamental right involved. So intention one way, statutory text one way. Now we've got a third test, importance of fundamental right involved. Secondly, their lordships stressed that the proposition that ambiguity in the statutory language is not a prerequisite to the operation of 3.1. Ambiguity is not your lordship's poll star. Thirdly, 3.1 might thus have a role even if the statutory language is not capable of bearing two meanings. Lord Nichols says, once it is accepted that 3 may require legislation to bear a meaning which departs from the unambiguous meaning the legislation would otherwise bear, it becomes impossible to suppose that Parliament intended that the operation of 3 should depend critically upon the particular form of words adopted by the parliamentary draftsman in the statutory provision under consideration. That would make the application of 3 something of a semantic lottery. From this, the conclusion which seems inescapable is that the mere fact that the language under consideration is inconsistent with a convention-compliant meaning does not of itself make a convention-compliant interpretation under 3 possible. So this is impossible, impossible. So your lordship's ultimate guide star is intention, no. Text, no. Parliamentary, overall purposive theological, no. But the ability to achieve a convention-compliant result. A convention-compliant result. Next page, at page 10, I'll just read the quotation. Fourthly, their lordships considered that 3.1 empowers the court, if necessary, to change the meaning of the legislation. This is actually the heart, the legal heart of this case is this, interpretation, how to look at these sections. 3 enables language to be interpreted restrictively or expansively, but a 3 goes further than this. It is also apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention compliant. It is apt to require the courts to read in words which change the meaning of this enacted legislation so as to make it convention compliant. In other words, the intention of Parliament in enacting 3 was that to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of both primary and secondary legislation. Their lordship's view is not the touchstone in determining whether a convention compliant reading of legislation is possible, begs the question. If not the words, then what? How then is one to sort the sheep from the goats? Their lordships identified 2 overlapping limits. So now he's answering the question, how do you separate the sheep and the goats? What is possible under 3.1? This is the first test, fellows. General thrust of the legislation. Second is court's institutional capacity, which is defined later on, coming out later. As to the first, their lordships held 3.1 does not authorize the courts to adopt a meaning that is inconsistent with what they variously described as fundamental feature of legislation, underlying thrust of legislation, grain of legislation. Each of the footnotes gives a lot to the para. A cardinal principle of legislation, the very core and essence, the pith and substance of the measure. Well, to take a 5-second aside, it is a kind of a basic features intra-legislation, basic structure doctrine intra-legislation. Right. These are very interesting developments. Your Lordship is.
The tenor and the provision
Tenor.
of the law.
Exactly.
That internal, does it make internal
Intra-lens.
sense?
It has to be intra. It
Therefore, you
can't.
can't confine it to.
Correct.
Wow.
This notion that the courts cannot turn, page 11, 11 top. This notion that the courts cannot turn the scheme of the legislation inside out overlaps with the second point, which is that the courts cannot make decisions for which they are not institutionally equipped. Now, what is the meaning of this? Some cases that lordships held call out for legislative deliberation. So, if it's a case where lordship finds the whole Muller's script has to be written, it has to go to the legislature. This might be the case, for example, if the exercise of making the legislation convention compliant would involve the substitution of a detailed statutory scheme. It's a very fair test, fellows, very fair test. Or if a policy choice needs to be made between different methods for achieving convention compliance, or if the decision would have far-reaching practical repercussions, the courts are not well equipped to evaluate. This has to go case by case, fellows, to your lordship's ultimate decision. Now come to 13, page 13, 1.3. In Ghaidan, however, lower part, second half of the page. In Ghaidan, however, the House of Lords rejects both a focus on text and a focus on purpose. I'm sorry, Justice Kohli doesn't have page 13, lower part. I'm just doing a little bit of speed reading, Your Lordship's permission. Now, Your Lordship, teleological purpose, Bennion. So, even that is out. Both a focus on text and a focus on purpose. This creates something of a puzzle as to what their lordships might mean when they say that the interpretive possibilities created by 3 are limited by the underlying thrust, 1, of the legislation. Considered in isolation, that proposition might sound a restatement of the modern purposive approach to statutory interpretation. The purposive approach has, however, been explicitly rejected by their lordships. The intention of Parliament in enacting the relevant legislation must, they said, give way to the intention of Parliament in enacting. That the underlying thrust approach is not consonant with the purposive approach is manifestly evident from their lordships' analysis of the statutory scheme, page 14, top colors, at issue in Ghaidan itself. Lord Nichols postulated that the social policy underlying the extension of security of tenure in 1988 to survivors of de facto opposite-sex relationships was equally applicable to survivors of de facto same-sex relationships. On the basis of that essentially normative conclusion, he held that the underlying thrust, this is the test for us, the underlying thrust of the Rent Act of 77 did not preclude a convention compliant interpretation.
So then
The underlying
two parts. One is, yes, this is how you make it consistent with the convention. The second is they abandon the purposive construction method.
And the textual and the intention based. Now, if your lordships were to find
was it diametrically?
if there's a prohibition, I would say, in fairness, the answer would be no.
Then
If the language is diametrically opposite.
Interpreted to
No,
choices
the lordship is, when your lordship puts that question, I am answering it saying that diametrically opposite must mean prohibition.
The prohibition, that could be.
Prohibition.
We are looking.
Answer has to be no.
let
I'm
us-
not here, Bolos, to suggest your lordship that your lordship has a prohibition and your lordship is then overriding it on the basis of interpretation. Then your lordship may be able to override it for Bolos some second argument. It's not the only answer. Second answer is
But if
your lordship
provision,
as not constitutionally compliant.
then when
There are
we-
two ways of looking at this. One is that we challenge it on the ground of unconstitutionality, as we are doing the notice and objection provision to which I have just to turn. Your lordship will then apply that test. The first test my Lord Justice Narasimha is asking me is intra-legislation. To that the answer would be if there is a prohibition and I still ask you to only interpret. Your Lordship may have
How can
difficulty.
we confine to that concept that if there is a prohibition, then only we say that it should go back to the
that's
legislative
right.
drawing board? Because
No, if it's not constitutionally compliant on the larger challenge, no, your Lordship can strike it down.
because let me complete. We are focusing our gaze on the only provision. In Gaidan, it was possible. Gaidan, the question was simple. And also, Gaidan was not essentially concerned with matrimony. Essentially, it was concerned with protecting tenants and whatever was the consequence if one of them
Yes.
who was living in a relationship died. So therefore, it was possible to not even go into the internal mechanics of the concerned enactment. Here, perforce, whether you like it or not, we will have to insert ourselves into the mechanics of.
Therefore,
Yeah.
Manas, therefore, two things. Ghedan, the underlying, although the issue was Rent Act, the underlying thrust was found by all 5 judges to mean that you cannot discriminate between heterosexual couples
Given.
versus homosexual couples in the interpretation of that act. Number 2, the question would be if your Lordship found that SMA, the underlying thrust, is not this, or the SMA precludes that underlying thrust, then your Lordship would go one way. If your Lordship, however, to find that the underlying thrust of SMA does not exclude, and that's the heart of the answer to my Lord's query,
Preclude as-
does not preclude or exclude a same-sex couple, that's follows, therefore, that choice ultimately
See,
follows the,
If presented the way Gaidan is presented, we have no difficulty. But if you take the steps in Gaidan, which is the internal sense of the enactment, then we will necessarily have to go into
the
other
two
provisions.
different acts. Lordship, naturally, this is Ghedan is something
Then-
else, this is
then
something else.
Then
I'm only on the
the
approach.
route
to
which
interpret-
we may have to take is something else.
Well, I'm only giving your Lordships a approach to
Yes, you're
interpretation,
right.
which should commend
It's-
your
it's
Lordship,
quite a
obviously in a
novel-
different context.
It's a
Obviously
very novel approach.
novel approach and in
But
different
having
context.
said that, here you're really leading us on the path of statutory interpretation.
That's true.
Statutory interpretation, not based on text, not based on intention,
Go beyond.
not based on original intention, not based on purposive teleological
So
interpretation.
you're really asking us to read into the statute the expression spouses for really man and woman.
So
And
does the
therefore-
underlying thrust of SMA exclude your Lordship's reading or insertion or understanding of that construct? Is the
Because
case?
your principal premise is that when the legislation was enacted in 1954,
Yes.
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage,
Absolutely, absolutely.
right? And not,
Special categories.
you are giving Parliament was intending to provide an avenue to people beyond
Beyond.
your religious, the religious governance of marriage, so to speak.
There was also an aspect of endogamy.
Yes.
There was
Yes,
an aspect
yes.
of endogamy
yes,
which
yes.
we cannot ignore.
Yes, yes, yes.
So
yes.
it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to
And
be a very
therefore,
special
after
category.
1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable
That's
relationship.
because you go back and
Therefore,
say, yeah.
By decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, if the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law,
Lordship.
then surely that law is capable of being broadly read according to you, so as to take into account more stable relationships
Let me put it
of the
bluntly.
same
Very
sex as
grateful.
well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have
This is
considered them.
way of
That
looking
makes
at
no
it.
difference.
You may
Another
not.
way which you are perhaps propounding is this provided a framework, but that framework is of the concept of marriage. The
Exactly.
concept of marriage transcends
As it
contemporary understanding to
It's an evolving
Comprehend-
dynamic concept. Absolutely.
comprehend an evolving idea of
Dynamic,
marriage.
very dynamic concept.
So used in a constitutional sense, it only provides a framework.
Framework.
And that framework is broad enough to, assimilate later
Well,
developments.
I
So it
don't want to
transcends the existing.
I don't want to sound well as that is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Ghaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new
or
statutory
would
scheme.
yeah, exactly. Would the
New
court be
statutory scheme.
rewriting the entirety of the statute? Would the court really be making policy choices which is for the legislature to make?
Lordship.
So long as we don't straddle that line which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The
But
first test was
equally, I
enough.
think the impact of
Put a
Ghaidan
line.
is to liberate the court
Yes.
from the very, very traditional approach
Yes.
of looking at everything as a matter of statutory interpretation. Therefore,
Got it.
purposive interpretation also falls back on interpretation of that statute and the language of that statute.
That is important, Malas. That teleologic and purposive also, which is supposed to be in
play
advance,
again-
falls
play
back.
again- I'll play a little bit of a spoiler. Gaidan provided the framework for the introduction of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years for these to be recognized as marriages. So that too is an aspect which we will have to keep somewhere in mind.
Absolutely, Malas. Your lordship, that's the difference. It's a holistic thing your lordship keeps in mind. Ultimately, the feel of the case is only your lordship will. That is, nobody can be identical. Nobody is saying
Because
it.
I'm sure if you go to Gaidan and if you follow it up, there could be other cases which have followed
Now,
that.
that, so I've now Malas, time, given
And
my
Dr.
time.
Singhvi,
I've
we
done
have,
this.
Dr. Singhvi, I think, I mean, looking at India constitutionally and socially as well,
Yes.
we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under Section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation. Once we have made that, we have crossed that bridge, then the next question is as to whether our statute can therefore recognize not just marriage-like relationships, but relationships in the relationships
On the
of
contrary,
marriage.
Malas, I started by saying it's a logical move in the same direction. It is, in fact, little done, vast undone. Your lordship is now getting to cover that territory because to merely decriminalize is one category. Otherwise, it does, in an actual daily sense,
Of
remain
course,
a
it
shell.
requires us to, of
Hollow
course, it
shell.
requires us to redefine perhaps the evolving notion of marriage, because is the existence of two spouses who belong to a binary gender necessary, or the requirement for a relationship of marriage? Or has our law now progressed sufficiently to contemplate that the existence of binary genders may be, but is not necessary for your definition of marriage?
And Malas, to that comes in the intersection of the Article 14. You in your counter and everywhere else are underlining immeasurably the vital importance of marriage, to which I bow down.
Or
But that vital
or by
importance of marriage is
expanding that
restricted to one category.
Expanding that definition, are we then trenching upon that area which Gaidan excludes to the judges?
That is, Malas, in case your lordship has got to stitch a whole cloth, which only a statute can do. That ultimately will be your lordship's Malas, call. I don't think at all, which now Malas, lordship will just note on the side, para 44 has some other cases similar to Gaidan. I'll not read them. I don't have time to read them. Para 44 of my submissions. I'll now come to Malas that 3 or 4 queries arising under the SMA, and then come to the notice of objections regime.
But in a way, Dr. Singhvi, I think what happened in the UK is really, in that sense, not in that. I was just talking to Justice Call, is not really in that sense in all fours with what happened in India.
Not at all.
The HRA in the UK was intended to enforce treaty obligations under the ECHR,
Yes.
right? For us, we've always had the overarching principles of the
Well, that's
Constitution,
the-
which lie above in
That's
that.
the irony. We are A for sure, Manoj, with respect. I am saying on interpretation. This case is cited and the article is cited only for an approach to
And
interpretation.
you know, we are not
far
here,
ahead.
we are not here using the Constitution or utilizing the text of the Constitution to either read down a statute or to strike down a statute. That's one element of the impact of the Constitution. The other thing which we are doing now here is expanding the meaning of a statute in the context of constitutional guarantees. And in that, you are saying be liberated from the bare text of the Constitution or the notion of
That's the
parliament.
first part of what I argued yesterday was dignity, non-discrimination.
See, in the backdrop of constitutional interpretation, we have never used the originalist doctrine, right? India,
Lordship, in any case, not. America has
unlike what
lordship,
Justice
not.
Kalia said, we have never regarded ourselves as bound by an originalist interpretation
Kalia
of
is
the
an extreme
Constitution.
example. Manoj.
In which case, Dr. Singhvi,
Is an
if we have
extreme
never been bound by an originalist interpretation of the Constitution, should we be bound by an originalist interpretation of the statute,
statute. Correct.
which is in that sense subordinate to a constitution?
And he, Manoj, their lordship knows that a court of one. He said, if I am the only one, I'll always stick to this original intent. Court of one. So, Manoj, absolutely. Your basic, so all that I'm saying is, one, because I've done the constitutional aspect, yes, unless your lordship anchors it in the values of 14, 15, 16, 19, 21. That's the
But
first
to
part.
put it really bluntly, is the relationship between a man and a woman
Yes,
so fundamental
yes,
to our law and therefore the Special Marriage Act
yes.
that for us to comprehend that it will also include a relationship between a same-sex couple would be completely redoing the tapestry of the legislation.
So, this
If we
is, Manoj,
say yes, then obviously we cannot
is the
accept your
underlying
position.
agnostic
We-
thrust, is the underlying agnostic thrust of SMA antithetical to your lordship's recognizing what Article 14 normally will always include, namely same-sex persons enjoying the same importance and benefits of marriage as different sex persons. That's the long and short of it. As an aid to interpretation, I've only cited one case which says, and the only interpreted statutory out of the Constitution. Does the underlying thrust, alternatively, an interpretation of SMA, prohibit or preclude your lordship from doing so? Or is your lordship's institutional capacity so compromised by a particular case that your lordships cannot do it? That's the fourfold way, connecting yesterday and today.
And really, your argument is that, you know, the institution of marriage in itself
Yes.
is so very important that
to my
to deny it to same-sex couples would be really contrary to fundamental constitutional values.
sorry to interrupt my Lord the Chief Justice, but my note yesterday I said it, para 15 lists 7 important indicia of marriage and the appendix
Right.
lists more. Their counter says so. I rely on it heavily. The question is only exclusion. You have it for that side of the table, you don't have it decided. Para 15 of my submissions. My Lord was kind enough to note it down also by hand. Now, without that, if I was to straight away jump into an interpretation exercise of Ghaidan, it would be wrong on my part. I'm completing my argument.
Dr.
I'm
Singhvi, we're just reminding you it's 12:17.
No,
Now, Ghaidan is over. This article
No,
is
therefore,
done. We've got the trust. Now, what's the next one?
the next one. Now, let's very quickly. One, I'll be very pointed. Justice Bhatt put a question to me about Justice Lahoti's order. That's 2005, 3 SCC 313.
That yesterday's.
Don't bother, Malas. Just I'm giving a copy to your lordships. Just note, it was a different case. Justice Bhatt said so yesterday. It's a different case. Context was different. It was, Malas, really about,
What about?
again, a tenancy law invoked, Malas, by.
This was in the absence of the domestic.
Deserted wife to claim tenancy, etc. But leave that, Malas. Para 1, your lordship will note, the words are evocative. I'm just moving on. Just para 1 of that, Malas.
Dr. Singhvi, what exactly? 2005, 3 SCC?
2005, 3 FPC 313. Just note para 1. I'll read it fast, fellows. Lordship need not open it. I'll just read it for Lordship. Only para 1. The law, it connects with what I'm saying, and therefore, your Lordship put this question to me yesterday. The law does not remain static. It does not operate in a vacuum. As social norms and values change, Laws too have to be reinterpreted and recast. Law is really a dynamic instrument fashioned by society for the purpose of achieving harmonious adjustment, human relations by elimination of social tension and conflicts. I'll leave it at that, because that's just a